and I'm to the Advocate Association Bengaluru for giving me this opportunity. The Advocates Association needs to be complemented webinars like this. Knowledge is perhaps the only thing it gains in the sharing. I have borrowed the subject of my talk today from the title of Palkiwala's famous book, A Constitution Defaced and Defiled, in which he speaks of the Constitution being desecrated. It is in that background that the Keshwananda Bharati case propounded the doctrine of basic structure, the purport of which is that while the power of Parliament to amend the Constitution, the constituent power is plenary, yet it should not be exercised in such a manner as would destroy or abrogate the Constitution's basic structure or framework. The question then immediately arises, is it only Parliament which amends the Constitution and the executive government which proposes the amendments that may deface and defile the Constitution? This is what I would be talking about today. Or is the other wing also not free from blemish? This is a matter of seminal importance and calls for serious deliberation, and to which we shall now turn. Every institution is liable to err. There could and would be aberrations. But as long as such aberrations are noticed and corrected, there's nothing much to complain. But if aberrations become the rule or occupy a large space, then there is a problem. And when that happens to so important a wing as the judiciary, the Supreme Court, which is the guardian of the Constitution, the question is, who guards the guardians? Quis custodiet ipsos custodius? This can happen in a variety of ways for different reasons when constitutional conventions and limitations are wittingly or unwittingly contravened. We are a constitutional democracy where constitutional supremacy prevails, which means every institution is controlled and regulated by the Constitution. The various checks and balances in the constitutional scheme, particularly the separation of powers, not in a doctrinaire sense, but in a pragmatic sense, is perhaps the most fundamental attribute of every democratic constitution, which has to be nourished. But a large number of decisions of the Supreme Court have breached this principle and upset the delicate balance, resulting in what one might say, defacing and defiling the Constitution. The extensive and expansive use of judicial review and constitutional adjudication as an instrument of what is perceived to be good and reformative may give rise to profound controversy, legal, political, and social. Today, no admirer of the court and the rule of law can hardly avoid worrying that progressive politicization and activism are jeopardizing the court's historic role. Public law must, in principle, respect conventional limitations on judicial power, which are crucial to the functioning of a democratic state. The basic major premise of the Constitution is that what obtains is limited government. It has been consistently laid down by the Supreme Court that all organs of the state are creatures of the Constitution with no unfettered powers. The Constitution has devised a structure of power relationship with checks and balances. Law cannot provide for every contingency and the vagaries of human conduct. The majestic vagueness of the Constitution leaves room for doubt and disagreement. These are the profound words of Judge Learned Hand. It's therefore said by critics that this also leaves room for and invites government by judges, especially those who are free not only of appellate review, but of elections also, and have an assured tenure. Constitutional choices have to be made, policy initiatives taken, and legislation consequent thereto or supportive thereof enacted. The sovereign prerogative of choice, including the right to experiment and err, belongs to and should be exercised by the executive and legislative branches. If judicial modesty and restraint are not accepted in matters of policy and lawmaking, then it would be government by judges. It would be judicial imperialism without political accountability. No system is perfect. The actual unfolding of democracy and the working of a constitution and institutions under it may suffer from inadequacies and imperfections, but these cannot be sought to be redressed by judicial drafting or redrafting of legislative provisions or formulation of policy. Indeed, the Supreme Court very emphatically and neatly emphasized, in a democracy based on the rule of law, government is accountable to the legislature and through it to the people. The distinction between what lies within and outside the power of judicial review is necessary to preserve the sanctity of judicial power. If the restraints are not maintained, the court as an institution would invite a justifiable criticism of encroaching upon a terrain on which it singularly lacks expertise and which is entrusted to the legislative and executive arms. Profound words, but often I would submit there is a mismatch between what the court says and what it practices. The court, in our scheme of things, administer justice according to law. We have to distinguish the Constitution and law in general from those passionate personal commitments called justice. Many a time in the court's eagerness to do what it deems to be justice, the judicial process may get distorted. Public interest litigation, originally conceived as a jurisdiction firmly grounded in the enforcement of basic human rights of the disadvantaged, unable to reach the court on their own, has over the years transformed into a correctional jurisdiction that superior courts now exercise over governments and authorities. These micromanaging exercises, if we may call them, are hung on the tenuous jurisdictional peg of Article 32, read with Article 21 of 14 and 142. Really speaking, no legal issues are involved in these cases, nor is this the exercise of a judicial function. The court is moved only for better governance and administration. Suffice it to refer again to what the Supreme Court has so eloquently said. Jurisdiction under 32 is not a panacea for all ills. Courts are concerned with issues of constitutionality and legality. Every good perceived to be in societal interest cannot be mandated by the court. The remedies for perceived grievances regarding matters of public policy and governance lie with those who have the competence and constitutional duty in that behalf. Unquote. Article 142 is not a source of carte blanche power. It is only for doing complete justice in the cause before the court. It is bounded by the requirement that the court acts within its jurisdiction in accordance with the law. And it's not the freedom to implement what it considers its vision of justice. regardless of the concerns of legitimacy and jurisdictional and institutional prestige. No doubt Articles 32, 14, 21, undoubtedly great rights by any canon, as Justice Krishna Iyer would say, and judicial review by promiscuous misuse, to borrow the language of the Supreme Court in Ganga Sugar Corporation, have given the impression of being the heaven of busybodies and interlopers. Article 32, a fundamental right, is to be invoked for the protection of fundamental rights. It is incomprehensible in many cases as to the infraction of which and whose fundamental right is being agitated. Equally, if not more distressing, is when citizens approach the Supreme Court for real violation of fundamental rights, for the protection of which that court is constituted, the sentinel on the highway. The court many times grandiloquently relegates parties to the High Court, thus abdicating its duty and function. Locus is not merely technical. In PILs, the court has to unveil and see who is seeking to invoke its jurisdiction, whether they are those whose rights are really infringed or those genuinely approaching on behalf of such persons, or is it merely those who have an agenda of their own and disguise it as an infringement of rights of the disadvantaged, or simply try to espouse what according to them is good governance, or again those who come for political reasons, camouflaging that as enforcement of fundamental rights. These are serious issues which cannot be glossed over. In the process of interpretation, in deciding matters, judges make law, but only interstitially. Law is molded and sometimes changed by this process, which of course is quite legitimate. However, we can't forget that this is subject to what may be called legislative oversight, meaning thereby it is amenable to being overruled by the legislature by enacting a new law. It is thus subject to correction by popular sovereignty. People elect the legislatures who can influence the law being changed. That at least is the theory. It's however not uncommon today for the court to exercise full-fledged legislative and executive power and travel into domains not its own. In this process of legislating or issuing directions touching matters of law and policy, many constitutional limitations are breached. Legislative and executive actions are tested and corrected by the judiciary. But judicial action, which partakes of both legislative and executive character, leaves one aghast and remediless. If the salt has lost its savor, wherewith can it be salted? It's interesting that in many of these cases, the Supreme Court refers to its earlier decisions, recognizing and emphasizing the importance of the doctrine of separation of powers in our constitutional scheme. Yet, the court, while rendering judgment, bypasses the tenet of restraint inherent in the doctrine. It's apposite to recall Justice Cardoso's insightful admonition in his beautiful classic, The Nature of the Judicial Process. The judges have the right to legislate within gaps, but often there are no gaps. The difficulty lies in the failure to distinguish between right and power. They have the power, though not the right, to travel beyond the walls of the interstices, the bounds set to judicial innovation by precedent and custom. Nevertheless, by the abuse of the power, they violate the law. The exercise of judicial power is sometimes legislative in character. But then we must clearly bear in mind the distinction between what is legislative and what is legislation. Legislative determination of disputes has been held to be absolutely illegal and impermissible in leading cases like Amirunisa, Ram Prasad Narayan Sahi, Indira Gandhi, and the like. By the same test and token, judicial legislation, which is judicial determination of policy and law, cannot be sustained or justified jurisprudentially. Judicial legislation is primary lawmaking by the judiciary, which appears to be wholly unjustifiable. I draw your kind attention to the propositions in Vishaga and Vinith Narayan. Both cases which brought about salutary results, but that's another point. That's beside the point in what we are now talking about. The proposition that the executive must step in when there is no law, and when the executive does not act, the judiciary should do so by virtue of powers under Articles 32, 73, 141, 142, 144. This is absolutely nebulous and unsupportable. Executive power is coextensive with legislative power. That is a constitutional principle. If the field is unoccupied by legislation, the executive can fill the gap. The rationale for executive power being coextensive with legislative power is that we are a parliamentary democracy, and in a parliamentary system, there is more blending and fusion than separation between the legislative and the executive wings. One may refer to the leading judgment in Ram Javaya in 1955, Chief Justice Bijan Mukherjee's judgment. This is a special feature of the parliamentary system of government. So if the field is unoccupied by legislation, the executive can step in and fill the gap. However, there is no sanction whatsoever that by reason of these constitutional provisions, the courts can step in and legislate. There is no such principle as judicial power being coextensive with legislative and executive power. Such a proposition would endow the judiciary with all the three powers, executive, legislative, and judicial, which would be a constitutional anachronism or monstrosity. It is not uncommon these days that some decisions which annul state action leave third parties and those not before the court high and dry. Declarations of law operative retrospectively, upsetting past transactions and divesting vested rights. Some such orders even trench upon and violate fundamental rights of those not before the court. This, I submit, is an affront to the rule of law, which our courts so emphatically profess. That judicial orders cannot violate fundamental rights is a constitutional conundrum and may not survive, especially after Antule. But the court still seems very hesitant to declare this correct legal position. Leaving people remediless in such situations when there are genuine grievances effectively means denial of justice by actions of the court, which is the dispenser of justice. It can endanger despair and chaos. As Sirvai very graphically points out as an illustration, if a judge denied discretionary orders of a particular kind to a particular set of people, while granting them under similar circumstances to another section, it is difficult to see how the court can shy away from its duty of nullifying such action as violation of fundamental right. You have Justice Frankfurter's very beautiful enunciation. If the highest court should candidly deny to one litigant a rule of law which it concededly would apply to other litigants in similar situations, could it escape condemnation as an unjust discrimination? It is not inconceivable that a judge may commit breach of Articles 14, 15, 17, 19, 20, 21, 22 by judicial orders. As the Almighty does not share his omniscience and infallibility with the judiciary, it would be naive to suggest that judicial functions can never result in breach of fundamental rights. This is Chief Justice Gajendra Gadkar's proposition in Mirajpur. Laying down such a legal proposition is merely shying away from the truth and an illustration of an egocentric exercise of power. There cannot be an artificial exclusion of the judiciary on any fragile ground. That judicial decisions cannot affect fundamental rights appears to be mere ipse dixit without any constitutional support. The superior judiciary also is a creature of the Constitution and cannot be placed on a higher pedestal beyond the law. It may be that such cases of violation may be very few and far between, but the court would have to examine and give a finding in every case as a proposition to say that judicial orders cannot violate fundamental rights would be constitutional blasphemy. And again, the existence of a remedy is not the test of the existence of a right. It's the other way around, ubi jus ibi remedium. The court examined in all those cases whether a writ of certiorari would lie to a court of coordinate jurisdiction. But that is, I submit, looking at the problem from a wrong end. In Pinochet's case, the House of Lords set aside its own decision as being violative of natural justice. Our Supreme Court, in Vinay Chandra Mishra's case, which came up before the Constitution Bench, Supreme Court Bar Association, and another, Al-Hawat's case, set aside its earlier decisions, accepting that they infringed fundamental rights, but it did not say so. In Hura's case also, the Supreme Court held that decisions of the court may be assailed and set aside. What is the remedy is another question. And I would submit that it is not necessary to issue a writ of certiorari to quash such offending judicial orders if they violate fundamental rights. It would be sufficient if there is a declaration to that effect. The vindication of fundamental rights against their breach by whomsoever is really the protection of the integrity of the Constitution. Now, coming to Articles 124 and 217, these provisions vest in the President of India, which is nothing but a metaphor for the Union government, the power to appoint and transfer judges of the superior judiciary in consultation with the Chief Justice of India. By judicial interpretation in the second and third judges' cases, consultation was held to mean concurrence, making the President a consultee. The Supreme Court innovated the apparatus and apparition of collegium, wresting the power of appointment of judges to itself, quite contrary to the language and intendment, the clear language and clear intendment of the Constitution. This was not interpretation, but rewriting the Constitution. That judges should be appointed by and with the concurrence of judges through a collegium, and otherwise it would infringe the independence of the judiciary and abrogate the basic structure, shows the absurd length to which the Constitution can be perverted. Pushed to its logical end, it would even mean that the constitutional process of removal of a judge is encroachment on judicial independence. I don't think anything could be more frivolous than this. Sir Aladi in the Constituent Assembly very perceptively said, the doctrine of independence of the judiciary is not to be raised to the level of a dogma, so as to enable the judiciary to function as a kind of super legislature or super executive. Now the basic structure. By its very name and the rationale, that basic structure doctrine is to ensure that the core of the Constitution, the Constitution's identity is not destroyed or abrogated. Basic structure and touchstone of testing constitutional amendments is and has necessarily to be what is contained in the Constitution as originally enacted, not what is added later, either by amendment or judicial gloss or interpretation, and whose legitimacy and correction itself may be open to serious doubt. There can be no greater distortion and defilement of the Constitution than the court referring to and relying on such gloss as the basic structure. When an amendment to the Constitution is challenged as damaging the basic structure, it would have to be tested with a reference to what the Constitution originally said, not with reference to judgments and later interpretations. Curiously and unfortunately, this is exactly what the court did in the NJAC case. Equally surprisingly, in spite of the very well settled position that basic structure doctrine is to be applied to test constitution amendments alone, in the majority opinion in the second Madras Bar Association case, it was very casually stated that the basic structure doctrine will apply to invalidate ordinary legislation also. This was assumed to be a logical extension. The same learned judge reiterated that casual view of his in his leading judgment in the NJAC case. Fortunately, the other judges did not join him in this, and one of the majority judges expressly held that a statute cannot be challenged on the ground it violates the Constitution's basic structure. That an ordinary law should pass this test of basic structure is non sequitur. It is governed by, to use Palkiwala's language, what is lazily assumed or hastily glimpsed or piously hoped. The Keshwananda doctrine represents a high watermark of judicial innovation, curtailing Parliament's power of amending the Constitution on some vague, evolving concept, incapable of definite or precise formulation, giving the judiciary a unique power of nullifying constitution amendments, particularly as we see the way in which the doctrine is invoked and applied. The basic structure doctrine shifts the emphasis of democratic constitutionalism and alters the very foundation on which constitutional power is divided between the plenary amending body and the judiciary. Ever since Keshwananda Bharati, the Supreme Court has been inventing constitutional limitations from supposed basic features, the list expanding according to the whim and fancy of each judge who opens the Pandora's box. The concept being imprecise, undefined, unchannelized, many a time, this is nothing more than judges erecting their prejudices and predilections into what seem to be constitutional principles and shutting the door for reform and change. This is a serious problem. More rhetoric than sound legal reasoning characterizes the actual exercises of annulling constitution amendments. This is naturally so, because the court is exercising a political judgment. Over the years, after Keshwananda, what was then thought of and understood as the limited scope of judicial control by the basic structure doctrine has been enlarged by subsequent pronouncements into a total judicial supremacy over the amending power. Successive judgments have simply proceeded on the basis that Keshwananda Bharati has held that an amendment to the Constitution cannot alter its basic structure. This has expanded in such a manner which was perhaps never foreseen or contemplated by its authors. And as Andarjuna tells us, it is doubtful if even its ablest and most vocal exponent, Nani Palkiwala, really argued for this outcome when he espoused implied limitations on Parliament's amending powers. The doctrine has now become a constitutional axiom and passed into the currency of legal and political thinking. It has become a political superstition. But such general acquiescence, however, does not detract from the fact that the theory rests on fragile foundation of an unexamined and assumed ratio. Time does not run in favor of its validity. It is worthwhile to remind ourselves of the wholesome exhortation of Justice Cardoso. The half-truths of one generation tend at times to perpetuate themselves in law as the whole truths of another, when constant repetition brings it about that qualifications taken once for granted are disregarded or forgotten. Very true when you think of how doctrines are applied and the consequences thereof. The problems of constitutional change and amendment are generally spoken of as if the principal danger was that a tidal wave of majoritarianism may suppress or ride roughshod over the rights of a minority. It is worthwhile to note the problem may arise equally, where a majority of the people wish for a change, but it could be prevented in the name of this doctrine and the supposed breach of some fanciful framework. This can tend to invite serious problems. The basic structure theory is a product of its time and history, having been in place for almost half a century. It may be difficult or perhaps even imprudent to dislodge it or even make such a suggestion. At the end of the day, the doctrine is neither an unalloyed blessing nor an unmitigated disaster. Like many other tools, it has to be judiciously and cautiously employed. It's a rare weapon to be used sparingly. Unjustified and indiscriminate invocation and application of the basic structure doctrine will itself be an abrogation of the Constitution's basic structure. As Justice Krishna Iyer very picturesquely said, it should not be like a Trojan horse to penetrate every legislative camp. That was Bhimsikji. Now, the Supreme Court has no supervisory or administrative jurisdiction over the high courts. It is only appellate jurisdiction in matters judicial. In fact, that brings to my mind, this is exactly the reason that 45 years ago in 1975, Justice D.M. Chandrasekhar, the then senior most puny, told Chief Justice A.N. Ray, when the High Court judges declined to permit the Chief Justice of India to sit with them on the dais, and when Chief Justice Ray wanted to know the reason, Justice Chandrasekhar said, "You have no administrative or supervisory control over us. If you sit with us, it would look as if you're sitting to inspect, and so we would not like it." To the further remark of Chief Justice Ray that he had to appoint judges to the Supreme Court and he would like to see how they function. Justice Chandrasekhar's response, as most of you elders would know, was typical and would sound like a fairy tale today. The great judge remarked, in that case, none of us is interested in your Supreme Court judgeship, but we will not allow you to sit with us. Where are we from 1975 to 2020? The Supreme Court ordering a High Court judge should not sit and discharge his judicial or administrative work, as in the case of Karnan, cannot pass muster. That's the sole. I'm not on the merits of whether he should or he should not. I'm only saying the Supreme Court had no role in it. That is the sole function of the concerned Chief Justice as master of the roster. There have been earlier cases where a judge of the Supreme Court and judges of different high courts were denied judicial work, but all that was at the instance of the concerned Chief Justice on the administrative side. But more important and more poignant is the fact Karnan did not appoint himself. The inadequacies and ills of the collegium system, so emphatically and enthusiastically entrenched by the Supreme Court, are brought home with a strange poignancy. There are many instances, I'll just refer to a few of them, where the court has outstepped its limits. In Salvajudam, the court was clearly, I would submit, in the wrong and outstepped its assigned role. It had no awareness of the ground realities that the state of Chhattisgarh and its police force had to contend with. The judiciary has no mandate or judiciary manageable standards to monitor a war or secure people's safety. BCCI case is another typical instance of the court usurping power belonging to someone else and also abdicating its essential power and function. The court observed it was not proper to clutch at the jurisdiction of BCCI to impose any punishment. Nevertheless, it directed a committee to do that and declared the committee's order would be final and binding on the parties. It delegated and outsourced its power to adjudicate and pronounce definitive judgment and impose punishment, virtually creating an extra constitutional system for the ills plaguing cricket. Jurisdiction cannot be conferred except by law. This seems to be an extracurricular adventure with no legal support. Unguided and uninformed power was adorned with the apparel of constitutionalism. It's not for the court again to take a lead in matters of reform and assign to itself a reformatory role. That is something for the people and their representatives to evolve. Judicial review cannot be of everything. Judicial proceedings must be informed by the great verity that the broad sweep of human history is guided by sociological forces beyond the ken of the noisy hour or the quirk of legal nicety. The court must be conscious of its own remoteness and lack of familiarity with many issues. It's a moot question. If the court is to decide what religious beliefs, practices, traditions, customs are or should be, then cannot anyone else other than the court decide what the law is? Grounding judgments in concepts like constitutional morality and manifest arbitrariness to annul a legislation is treading on ice. These are totally subjective without any objective standard or criterion and would themselves be arbitrary. Just as Khanna very sagaciously warned that far worse than executive arbitrariness is judicial arbitrariness. It is well-settled constitutional law and parliamentary practice that it is only after the head of state has opened the House with his opening address, the House is ready to and competent to transact business. A first session of a house commences only after the newly elected members take their seat and the speaker is elected. The house is then ready to hear the opening address and proceed to the business of the house. Until the opening address, there is no legal beginning of a new house. These are mandatory requirements, and any breach would render the purported proceedings a nullity. A vote of confidence is undoubtedly business of the house in which members exercise their rights as members. And it is to be only on the floor of the house. This has been well settled by a large number of decisions. But floor of the house is a term of art, which in legal and constitutional parlance, in the context of our constitution, means it is the house of the legislature duly constituted and ready to transact business. The Supreme Court's direction in the Karnataka case in 2018 that the pro tem speaker conduct the trust vote before the election of the speaker and the opening address is constitutionally untenable, and the consequent vote cannot be regarded as a proceeding of the house and is a nullity. The court repeated it again in the Maharashtra government formation case last year. There, the decision, of course, became infructuous because the chief minister resigned, but that does not absolve the decision of the vice of unconstitutionality. The Supreme Court has said time and again that nothing that flows from a law is an evil. So too, nothing that is opposed to law can be good, even if it comes from the Supreme Court. And this is quite apart from the much larger question that a court cannot issue any direction to the House or the Speaker regarding the business to be transacted or set the agenda. The House is the absolute master of its affairs, its proceedings, and the time and manner of conducting them. Such directions, I would think, have been complied with as a matter of grace and courtesy, not because they are binding and inviolate. We would recall in 1965, in 1964, in Keshav Singh's case, in the presidential reference, the legendary Homi Sirvai, appearing for the UP Assembly, told the Supreme Court that the legislature would not be bound by its orders and would not obey it. To a pointed question by Justice Subbarao from the bench, "You mean to say you will not obey our orders?" Sirvai replied, "That is clearly what I have said, as I have informed the learned Chief Justice in his chamber, and I repeat it in the court. We will not be bound by what you say." Court issuing orders to enforce a law or consider and do something in accordance with law is one thing. But directions like constituting a special committee to prepare and submit plans for interlinking levers and making that committee's decisions final, banning liquor sale on highways and the court defining what a highway is, requiring governments to issue final declaration for acquisition of land, all these are instances of the court usurping executive power. These are only illustrations, but I submit telling illustrations. They clearly show that they are not just aberrations to be ignored or noticed and corrected. Fortunately, they have not become the rule, but they seem to be eating into the vitals of our constitutional scheme and dispensation and need to be arrested. In law, the moment of temptation is the moment of choice. To give in to temptation solves an urgent problem, but a crack develops in the foundation of our system. This much and nothing less has happened in these cases. Judicial legislations or orders cannot be supported or justified because they may produce desirable results. Desirability is not the test of power. If that were so, law would cease to be what Justice Holmes called it, the calling for thinkers. Legal reasoning rooted in a concern for the legitimate process rather than desired results restricts the judges to their proper role in a constitutional democracy. There is Another pernicious development which needs to be mentioned. Sometimes government leaves it to the wisdom of the court to take a call on sensitive and serious issues. We should not forget that in a constitutional democracy, the moral content of the law, the wisdom of any policy, legislative or administrative measure must be that of the framer, the legislator, the executive, never the wisdom and morality of the judge. The executive government cannot abdicate its functions and responsibilities. Unconstitutionality, not unwisdom, is the narrow area of judicial review. For representative democracy to maintain its legitimate domain of activity, it's only appropriate that the social, political, and economic agenda for the nation is not set by the judiciary. Fortunately, courts have by and large not been enticed by this temptation. In fact, Justice Dhananjay Chandrachud in a lecture sometime last year specifically referred to this and said, we don't fall prey to this temptation. To even imagine that in matters concerning the people and the political process or socio-economic affairs, the judiciary has all the wisdom is a very dangerous proposition to live by in a democracy. The Constitution guarantees the liberties of self-government, the substance of which is not a nursemaid who lets the children play on condition of good behavior. The sine qua non of a successful democracy is that all citizens think for themselves about issues that arise. While it may not be unrealistic today to despise the political process, it would be puerile to think that guardianship is synonymous with a democracy. Very often we refer to a famous statement, the Constitution is what the judges say it is. This is an observation, extra-curial, of Charles Evans Hughes, who later became the Chief Justice of the United States. This was uttered in 1907, much before his elevation to the Supreme Court. But we must not forget that he clarified it later in a pronouncement in the Supreme Court in Carter versus Carter Coal Company, when he said it is not the function of the court to amend the Constitution by judicial decisions. And in Graves versus New York, Justice Frankfurter observed, and the other judges agreed with him, the ultimate touchstone of constitutionality is the Constitution itself, not what we have said about it. Equally profound is what Justice Black said. The public welfare demands that constitutional cases must be decided according to the terms of the Constitution, not according to the judge's view of fairness, reasonableness, or justice. I have no fear of constitution amendments properly adopted, but I do fear the rewriting of Constitution by judges under the guise of interpretation. Coming nearer home, Justice Bhagwati warned in the first judge's case that judges mending the language of the Constitution to their will would be rewriting the Constitution in the guise of interpretation. Unfortunately, in the many of the cases that I have referred to, this is precisely what has happened. The court, in the garb of interpretation, has rewritten the Constitution, resulting in its distortion and defilement. And one should not forget Justice Krishna Iyer, perhaps the most radical of our judges, who wanted judges to solemnly remind themselves of what Charles Warren, the historian of the US Supreme Court, stated. And I quote, "However the court may interpret the provisions of the Constitution, it is still the Constitution which is the law, not the decision." That many of these decisions have been accepted and acted upon does not clothe them with legitimacy, nor detract from the fact that the Constitution is disfigured and defiled. The court, by the manner of its functioning and its decisions, is also the exercise or non-exercise of jurisdiction, can and sometimes does infringe the basic structure. The wrong is not one that parliament and executive government alone can or do commit. When judicial activism spans into areas not marked for courts, judges try to frame principles to dispose of matters on what sound as legal grounds. This is what that great American jurist Robert Bork, who unfortunately lost his nomination to the Supreme Court, said. As the principle was devised to achieve something which the existing law did not permit, judicial power will have expanded into another new area. Many times it begins with an attitude, let us do it this one time. This grows into and becomes a distortion of constitutional government, impairing the deft and delicate balance. This is what courts must sagaciously avoid and resolutely set their face against. Having said all this, I am fully conscious of the fact that the problem with any suggestion to remedy the situation if and when the court acts or appears to act unconstitutionally is that it is likely to create a power which may tend to destroy the court's essential function, which is vital in a constitutional democracy. The only safeguard would be developing a consensus of judicial behavior and vice restraint, a consensus which by its intellectual and moral force regulates those who are subject, and rightly so, to no other discipline. That's the judges. All this, I submit, is not to forget or overlook the commendable work that the Supreme Court, which is an esteemed institution, has done over these long years. And we are prompted to repeat what was said of the American Supreme Court. The Republic endures, and this, that is the court, is the symbol of its faith. The Constitution, however, deserves to be preserved pristine and inviolate. In the final analysis, its only keepers are the people. To recognize that there can be no legal solubility to every problem, and that the judicial process also has inherent limitations, is wisdom, an acknowledgement of a stark reality. We cannot forget that during the emergency, the court failed to protect our liberties. It's the people and the people's representatives who ended the emergency and corrected the misuse of constituent power. Ultimately, it's the contemplation and judgment of the people which should be vigilant and strong, and which would ultimately prevent any perversion of the system. For this, it is essential that constitutional values and aspirations become internalized in the psyche of the nation. In saying all this, I very respectfully submit the idea is not to criticize or condemn. The endeavor is only to seek improvement. One is fortified by what Justice Holmes said, and I quote, I take it for granted that no hearer of mine will misinterpret what I have to say as the language of cynicism. I trust that no one will understand me to be speaking with disrespect to the law, because I criticize it so freely. I venerate the law, and especially our system, as one of the vastest products of the human mind. But one may criticize even what one reveres. Law is the business to which my life is devoted, and I should show less than devotion if I did not do what in me lies to improve it. And he also spoke of the secret, isolated joy of the thinker who knows that 100 years after he is dead and forgotten, men who have never heard of him will be moving to the measure of his thought. It is in this spirit of inquiry and humility that I have placed my thoughts before you. Thank you very much for your patience and courtesy. Trivikram, I hope I have not overstepped the time.
No, sir, you haven't. Thank you, sir, for an academically enriching session. Can we now move on to the Q&A session, sir?
Yeah.
Can we have the first question? Can we have the first question, please? All right, we'll start with Mr. Harish. Akash, request you to unmute Mr. Harish. Akash, request quickly to unmute Mr. Harish.
Yes, sir, good evening, sir.
Oh, good
Sudish Pai,
evening.
sir.
Good evening. Good evening.
It was like a HMV record. His master's voice of Palkiwala through your vocal card. Sir, when it comes, you just now spoke of the minister's disqualification, all those MLAs thing and judgment and things like 2019 November judgment admele, Vishwanath now being nominated as the member of the Legislative Council, whereas Article 361B subclause 1 talks about they are disqualified from even being a member of the, holding any post of ministry till they are elected to the house, either house elected. Whereas this is, suppose tomorrow if the government decides to make him the minister, will this article not, will the government not be violating this article because he lost the election? Thereafterwards, he has been nominated as a rehabilitation center. As we all know, a legislative council is like just a rehabilitation center. That too from the, by virtue of a governor nomination, Sahiti Kotadalli. Whereas the article says Sahiti, Sahiti ಅನ್ನೋ ಕೋರ್ಟ್ದಲ್ಲಿ ಅವ್ರಿಗೆ ನಾಮನಿರ್ದೇಶನ ಮಾಡಿದ್ದಾರೆ. 361B ಅಲ್ಲಿ it should say you should be elected to the house, to any either of the house of the Karnataka of the legislature.
Yeah. It would be in a way. It would be in a way. In any case, if he is made a minister, I think it would definitely but,
violate the article.
Yeah, but even that possibly you have a window of those 6 months.
Yeah, that is that.
Yeah, possibly. Yeah.
Possibly. But this rehabilitation center should stop, sir. I think we should abolish the. I think I have three opinion of mine. One is entry age for legislators to contest an election is there 25 years. There should be also an exit age, either 5-year term or a maximum age of 75 years, whichever is earlier. And the persons who have lost the election in a general election should not be given a backdoor entry into the into the legislature through the legislative council or the Rajya Sabha, because they have lost the mandate of the people.
That second part of it may be debatable because many times you lose the elections for a variety of reasons, and you may be denying the use of good talent sometimes. I'm not generalizing. I think you can't have universal statements.
That's true. Nice to hear you after a long time. So I have long time. Thank you. So we stay in the same neighborhood.
Thank you.
Thank you, sir. Can we have the next question, please? Akash, request you to unmute Mr. Rangarajan. Yes.
Sir, Sudish Pai.
Oh, namaskara.
Namaskara, ಹೇಗಿದ್ದೀರಾ?
ಪರವಾಗಿಲ್ಲ, ನಡೀತಾ ಇದೆ. How are you?
I am very fine, and I must honestly compliment you.
Thank you. A
very scholarly, a very courageous, a very enlightening debate on our constitution. It was reverberating like Krishna here, and you turned no stone unturned, because you made a very healthy criticism of the collegium system of appointment of judges. I am told India is one of the very few countries where judges appoint judges. It is a very strange thing. It is high time the associations should take up and streamline the system of the appointment of judges so that there is more transparency. My questions are twofold. My first question is, what would constitute a healthy criticism of the Supreme Court and what is not? There is perhaps a very thin line and veil. I would like to have your expert opinion on that first. I have one more question which I will tell you later.
Thank you. Thank you. I don't know whether it's expert or not, but I'll share with you what I
Please,
firmly believe. In fact,
please.
last week I have written on this. Live Law carried my article. I firmly and reasonably believe that any criticism is permissible. Let me just say a couple of things about it. I am not saying any criticism in the sense that, any irresponsible statements, no. But see, I would only recall, in 2000, when, the famous American election, Bush's re-election, and the American Supreme Court handed down the judgment in Bush versus Gore. And we will recall how the judges were criticized, not on the streets, but by scholars in leading journals, law journals, academic journals. They were called robbers by the day. This is the expression used of the 9 old men, the American Supreme Court judges, robbers by the day, for their judgment. They did not take any notice, and wisely so and rightly so. In 1987, after the Spycatcher case, the House of Lords was divided 3-2, and an leading English newspaper put up a cartoon. The pictures of the 3 majority law lords, head down, upturned, and with the caption, 3 old fools. Fully Nariman asked Lord Templeman, who was one of the majority law lords, he said, no contempt. What did they say after all? He said, 3 old fools. 3, absolutely accurate. We were 3 in the majority. Old, well, we are by no means young. Fools, matter of perception. I may think I'm the wisest man. You may think I'm an idiot. So what? No contempt. And last year or year before last again, in the Brexit case, after the Court of Appeal handed down the judgment, which then went to the House of Law, the UK Supreme Court, the Daily Mirror called the 3 judges of the Court of Appeal enemies of the nation. No notice was taken. And pardon me if I may give you another instance which I have heard. I have no personal knowledge of our own Supreme Court. I understand, I have heard it very reliably. It happened in the 1950s in Justice Mahajan's court. And Justice Mahajan, as we all know, was perhaps the exception to that first bench of being a little abrasive and rude. All the other 6 judges were the pink of courtesy on the bench. Kania, Fazal Ali, Patanjali Shastri, Mukherjee, Das. Mahajan was not in that category. In fact, P.R. Das had called him to his face, you're a rogue on the bench. Anyway, eschew, I understand. I can't vouch for this, but this is what I've heard reliably, and I have no reason to disbelieve. Eschew was thrown in the open court. Mahajan ducked and it went and hit the wall. And I would say, to the great credit of Justice Mahajan, he very graciously said, we can understand and appreciate the agony of a losing litigant in the final court. But then we have to decide according to our light. One party has to win, one party has to lose. We are helpless. But court master, ensure that no one leaves this courtroom barefooted. Please return the shoe. I think there can be no greater example of greatness and magnanimity. So I would think that, and in fact, I have suggested that scandalizing the court, it is this, that gets caught, that really gets into action. Scandalizing the court is a concept of illegitimate ancestry. Why I say this is, we have borrowed it from Justice Wilmot's judgment in Re Almond in 1765. That was a judgment where, of course, contempt of court action. But it is an undelivered judgment. According to the rules of procedure that then prevailed in England, the case had abated. More than that, the judgment was not pronounced. It was a draft judgment that Justice Wilmot prepared and kept, and he died. 40 years after his death, his son published some of the some of his judgments which were not pronounced. It is that judgment on which we base our law of scandalizing the judiciary, and therefore it is rightly called, not by me, by authors in England, Lowe and Borey, that it is dubious, controversial, of illegitimate ancestry. And to complete the story, England has abolished the concept of scandalizing the judiciary after the Law Commission report in 2012. In 2013, that concept is abolished. And therefore, I would very respectfully think, not that we should be responsible in condemning or criticizing, but if there is a criticism, it is an occupational hazard, as David Panic calls it. Does not any other profession, any other job involve criticism? Did we not say, Gali gali mein shor hai, Rajiv Gandhi chor hai? Whether it is right or wrong, I don't know, but you said it. I mean, you in the sense the people said it. I mean, this is part of the system when you're in public life. Well, it is, I would submit it's an occupational hazard. I wish everyone sees according to this light. I only pray. Thank you.
I have sorry, sir, I have one small question. You see,
it is all right. I mean, sir, is it okay what I said?
100% yes. Hats off. I have one more question.
Please, sir.
See, the rich, the politicians, the influential in the society, they approach the court, Supreme Court today. Tomorrow their cases are listed, heard, disposed of. Whereas matters arising pursuant to a first appeal, second appeal, other matters rising, very complicated legal issues, of civil nature, they are not touched. A civil dispute today also takes 20 years for disposal. Is it not violation of my fundamental right? Speedy justice is a fundamental right. Am I correct or not?
Possibly, it's plausible. I wouldn't assert it is, but it is plausible. And there are many matters pending. In fact, I understand even presidential references are pending for 20 years. You know, where you seek an opinion of the court. See, the whole problem is, I mean, it's difficult. Of course, I know it's no easy job for the judges there. That's the thing which we can't lose sight of. But my own small feeling is whether, you know, we are lost in the, on the edges without really getting into the core of the problems. See, the whole structure of the Supreme, that's a larger issue. When you say the Supreme Court, though at the head of the hierarchy, it is not just another court of appeal, it's a constitutional court. Its business is more serious than disposing of SLPs. See, most of the time, most of the judges spend days and nights in reading their SLP briefs. I'm no one to comment on that, but the problem is, the question arises, do they have sufficient time to bestow, to think of the more serious problems on constitution benches which they have to sit and decide? SLPs affect two people, two parties, but constitutional questions which as a constitutional court they have to decide is a larger issue. I mean, it's a question of balancing. I'm not for one moment trying to belittle anything, but this is a serious problem. Thank you. Thank you.
Thank you, sir. We can have one last question, Mr. Lakshminarayan. In fact, he had asked me during the beginning of the session, sir, you can pose your question. Akash requests you to unmute him quickly.
Good evening, respected President and Secretary of the your association. I am really one of the fans of your speaker today. I am delighted to participate in this webinar. My name is Lakshminarayan and I am the President of the Kerala High Court Advocate Association. I just wanted to convey the wishes from our association to your association and our respect and regard to the speaker. Thank you very much for a link. Providing the link. I thank the secretary. He was pleased to, provide link through the WhatsApp group now constituted by the Bar Council of India and all High Court, State High Court Bar Association. It was a feast of legal principles, and as usual, he has in a very deep depth, greatest depth, went into all issues covered by the title. So I am greatly indebted to the association of office bearers as well as today's speaker for enlightening speech and this webinar. Thank you.
Thank you. Thank you.
Thank you, sir. I see a lot of people raising their hand. Apparently, you will have to forgive me. Due to the time constraint, I'll be able to take up only one question. Mr. Shivananda has a question. So, Akash, request you to unmute him. Akash, request you to unmute Mr. Shivanand.
Shivanand, sir, can you please unmute yourself?
I request you to quickly unmute yourself and you can pose the question. Akash, is Mr. Shivanand still with us on the panel?
No, he is not there. I think he left.
All right. Okay. So we can have one more question. So I'm afraid three people, regular viewers, they are all raising their hands. So I'm afraid whom to give. No offense meant, but of course, Mr. Gupta, sir, you can go ahead. Just on the basis of seniority, I have just chosen.
Thank you, Trivikram. Sir, Justice D.M. Chandrasekhar was transferred from Karnataka High Court to Allahabad High Court.
I know, yeah.
During the emergency. Okay. Then, sir, what is please explain the difference between the basic structure and the basic features of the Constitution.
Yes, sir. Now, can I take 2-3 minutes so that it's not yes, no, and type of. Trivikram, do we have 3-4 minutes?
Please go ahead with yours.
In the first place, the doctrine itself, I would submit, has no jurisprudential legs to stand. Last year in Delhi, in honor of Palkiwala's centenary, I did speak on the basic structure doctrine, genesis, nuances, and perils, where I espouse the view that it's a doctrine without foundations. Though, of course, excellent, it has done a lot of good. That's another matter altogether. Now, basic features and basic structure. In fact, before all this came up in this, in the same book from where I've borrowed the title, Our Constitution Defaced and Defiled. If I'm not mistaken, at page 149, Palkiwala speaks of basic features and basic structure. Now, basic feature is, from what I can understand, a particular feature. Now, democracy is a basic feature. Republicanism is a basic feature. Equality is a basic feature. Basic structure would mean the sum total of basic features is the basic structure. And it is therefore that Palkiwala said, by the court propounding that you cannot amend the Constitution so as to abrogate or destroy the basic structure. It has left open Parliament's amending power to a larger extent by not saying that you cannot destroy the basic features. In the process, some feature may be upset. See, nothing in all this has been dealt very neatly in those cases in 1980. You have those 3 3 or 4 constitution bench judgments, Minerva Mills, Vaman Rao, Bhim Singh Ji, etc. And I think Krishna Iyer in his inimitable style has said that every minuscule violation of Article 14 is not an abrogation of the basic structure. It must be something much more pronounced. And it is there that is said that basic structure must not be like a Trojan horse to penetrate every legislative camp. So very loosely speaking, I think we can say basic features, each of them an attribute. Basic structure would be a sum total of the basic features. It's like saying, see, if I have a small pillar here, which may still be basic, but even if I remove the pillar a little this way or that day, the structure will not fall down, the house will not collapse. That, I think, to my humble understanding, that's the concept.
Load bearing walls should not be removed.
Yes. Quite so.
All right, sir. Thank you so much. Now we have reached the fag end of this session. With this, sir, I would like to extend my heartfelt thanks to you, sir, on behalf of Advocates Association Bangalore. Thank you very much.
Thank you.
I would also take this opportunity to thank our beloved Senior Advocate S.S. Naganand, sir, who has given me your contact number and who indeed connected us. All right, thank you so much, sir. And to all my esteemed colleagues and viewers, thank you so much. With this, we'll be ending the webinar.
Thank you. Namaskar.